Hello everyone, welcome to LBS IAS Academy. Today we are going to discuss Polity MCQs based on previous year UPSC questions. So let's start our session. Our first question is, which one of the following statement is incorrect? Option A, Goa attained full statehood in 1987. That is correct. Option B, Diu is an island in the Gulf of Khambhat. That is also correct. Option C, Daman and Diu were separated from Goa by the 56th Amendment of the Constitution of India. That is also correct. Option D, Dadra and Nagar Haveli were under French colonial rule till 1954. That is incorrect because it was under Portuguese colonial rule. So here answer to this question is option D. Daman and Diu is a former union territory in northwestern India. It was a separate union territory until January 2020 before it was merged with Dadra and Nagar Haveli union territory to form a single union territory due to its small landmass. Dadra and Nagar Haveli was under Portuguese colonial rule till 1954 and not French colonial rule. That is why statement D is incorrect. After liberation on 19 December 1961 from Portuguese rule for more than 4 centuries, Daman and Diu became a part of Union Territory of Goa under Government of India. After delinking of Goa, which attained statehood in 1987, Union Territory of Daman and Diu came into existence on 30th May 1987. Diu is situated on island in the Gulf of Khambhat of the Arabian Sea. So here statement D is incorrect. The concept of public interest litigation originated in options are UK, Australia, USA and Canada. Here answer to this question is option C, USA. The expression public interest litigation has been borrowed from American jurisprudence where it was designed to provide legal representation to previously unrepresented groups like poor, the racial minorities, unorganized consumers, citizens who were passionate about the environmental issues, etc. Public interest litigation means litigation filed in a court of law for the protection of public interest such as pollution, terrorism, road safety, constructional hazards, etc. Any matter where the interest of public at large is affected can be redressed by filing a public interest litigation in a court of law. According to the Constitution of India, the term district judge shall not include option A, Chief Presidency Magistrate, option B, Sessions Judges, option C, Tribunal Judge, option D, Chief Judge of a small court. The answer to this question is option C, Tribunal Judge. District Judge is a judicial officer appointed by High Court in consultation with the state government that works regularly on that post. It includes Session Judge, Chief Presidency Magistrate and judges of small courts existed earlier. The tribunals are created by the statute and for a special purpose to deal with a particular type of judges. The constitution of the tribunal, nature, extent and scope is determined by the legislator and hence the presiding officer of the tribunal is not included within the meaning of district judge. So here answer to this question is option C, Tribunal Judge. The power of Supreme Court of India to decide dispute between the centre and the states falls under its option A, advisory jurisdiction, option B, appellate jurisdiction, option C, original jurisdiction, option D, constitutional jurisdiction. Here answer to this question is option C, original jurisdiction. The power of Supreme Court to decide disputes between the centre and the states falls under its original jurisdiction. The original jurisdiction of a court is the power to hear a case for the first time. According to Article 131, the Supreme Court has original jurisdiction in any dispute between the Government of India and one or more states, or between the Government of India and any states, or between states on one side and one or more states on the other side, or between two or more states. In advisory jurisdiction, Article 143 authorizes the President to seek opinion of the Supreme Court. In appellate jurisdiction, Supreme Court can hear cases only when they are appealed against a High Court order. In original jurisdiction, there are certain cases which falls within the exclusive jurisdiction of the Supreme Court. It means that all such cases begin or originate in the Supreme Court. Consider the table given below providing some details of result of election to the Karnataka State Legislative Assembly in the past. In terms of electoral analysis, the voter seat distortion is to be explained as a result of adoption of option A, Hare system, option B, cumulative vote system, option C, first past the post system, option D, plural vote system. Here answer to this question is option C, first past the post system. Under first past the post system, voting takes place in constituencies that elect a single MP. Voters put a cross in a box next to their favored candidate, and the candidate with the most votes in the constituency wins. All other votes counts for nothing. Under first past the post electoral system, voters cast a vote for a candidate of their choice, and the candidate who receives the most votes wins. In hair quota is the minimum number of votes required for a party or a candidate to capture a seat. Cumulative voting is used frequently in corporate governance. And in plural voting, one person might be able to vote multiple times in an election. If in an election to a state legislative assembly, the candidate who is declared elected loses his deposit, it means that option A, the polling was very poor. Option B, the election was for a multi-member constituency. Option C, the elected candidate's victory over his nearest rival was very marginal. Option D, a very large number of candidates contested the election. Here, answer to this question is option D. If in an election to a state legislative assembly, the candidate who is declared elected loses his deposit, it means a very large number of candidates contested the election. A defeated candidate who fails to secure more than 1/6 of the valid votes polled in the constituency will lose his security deposit. So when a very large number of candidates contest the election, due to distribution of votes, the winning candidates may get less than 1/6 of valid votes. Which of the following is not explicitly stated in the Constitution of India but followed as a convention? Option A, Finance Minister is to be a member of the lower house. That is incorrect, as Finance Minister or any member of Council of Ministers can be appointed from any of the houses of Parliament. Option B, Prime Minister has to resign if he loses the majority in the lower house. That is correct. Option C, all sections of India are to be represented in the Council of Ministers. That is incorrect, as it is not necessary that all parts of India are represented in the Council of Ministers. Option D, if both the President and Vice President demit office simultaneously before the end of the tenure, Speaker of the lower house of the Parliament will officiate as the President. That is also incorrect, because in case of President and Vice President vacate office before the end of their tenure simultaneously, the Chief Justice of India discharges the function of President. If Chief Justice of India's office is also vacant, the senior most judge of the Supreme Court is available for the function. Hence, all other statements are wrong, only B is correct. PM resigns if he loses the majority in the House is a convention and is not mentioned in the Constitution. Conventions are unwritten practices which are binding on the three organs of the state. Unlike the President, the Prime Minister does not have a fixed tenure. The full term of the Prime Minister is 5 years, which coincides with the normal life of the Lok Sabha. However, the term can end sooner if he loses vote of confidence in the lower house. So it can be said that he remains in power as long as he enjoys the confidence of the Lok Sabha. The Prime Minister can also resign by writing to the President. There are no term limits on the office of the Prime Minister. There is also no official retirement age. The Dinesh Goswami Committee was concerned with option A, denationalization of books. Option B, electoral reforms. Option C, steps to put down insurgency in the Northeast. Option D, the problem of the Chakmas. Here, answer to this question is option B, electoral reforms. Dinesh Goswami Committee 1990 was concerned with electoral reforms. It suggested providing state funding in kind to political parties. It also suggested that a candidate should not be allowed to contest election from more than 2 constituencies. It also proposed to use electronic voting machines in elections.